Hi everyone, Harry here to talk about the big social media arguments in the Supreme Court. So yesterday and today, the Supreme Court heard arguments in what are being billed as the biggest big social media cases in a long time, and ones that have the potential to really change the legal regime around them. The backdrop is what matters here most. I'll tell you what happens in oral argument, but I imagine it's been a little hard to follow if you're just looking in regular news. So let me explain. The law, an important and controversial law known as Section 230, essentially says that social media like Google, like Twitter, cannot be held liable for just transmitting other people's information. So you do a tweet, it's defamatory. You could be charged with defamation. Now, it used to be that people would want to charge Google with defamation because they posted it right there, and that's where everybody saw it. And that's what Section 230 was about, essentially to unshackle them to be able to share all the information. And give a sort of model of what the way Google has always wanted to put it. We're just a newsstand here. We just collect things. You can come and read them, but if they violate the law, like defamation, that's not us. It's the person who wrote it and posted it. However, have you done searches? I suspect you have, where you put something in and somehow what comes back includes, your first grade teacher and your favorite food and maybe a cousin, and you think, how the hell do they know that? It's like these companies own me. The reason it feels that way is because Google and others use algorithms. You can put it in a benign way, you can put it in a sinister, brave new world way, but they know what you like. And so in order to, you could say, maximize the profits of targeted advertisers, or in order to give you what you want and you don't have to search so much, they use their own algorithms based on what you've looked at before other people have. And that's why when you do a search, the first few entries tend to be, this looks like what I was looking for. All right. The lawsuit in the Supreme Court yesterday was brought by the family. There are actually two, and the fact pattern applies to both, of people whose children were killed in ISIS attacks in Europe. How does that figure in Google? Well, they're arguing they want to sue Google for wrongful death on the theory that Google, with these targeted algorithms, is hyper effective in a way that makes them legally responsible at recruitment of ISIS and other folks. And we know that part is true. Like anyone else, they target, and you're someone who might go over to the dark side, flirting with ISIS. You put in, crazy search terms, and what's going to come back are, crazy searches or answers. And the killers of both people, somebody from both today and yesterday, were ISIS folks who were recruited. And you can't sue ISIS, so they want to sue Google and say, or once Google, once Twitter, and say, you're not protected because you did some extra, you put in your secret sauce that was damnably effective in getting ISIS people to be recruited. It worked. They signed up. They were in attacks. They killed my child. That is the basic notion in both cases. In one, the family lost, and that's the one that is Twitter versus the name of the family, because Twitter is appealing. Twitter in that one won, and then the other one is Gonzalez versus Google, or the other way around. But if you look at it, the first name, let's say Google versus Gonzalez, is the ones who lost below and so are appealing. It is actually Google that lost below in the Ninth Circuit. They come up, and it's now Google versus Gonzalez in the Supreme Court, and name of the person versus Twitter today. Okay, that sets the stage for the arguments, and they were interesting and a little surprising. All the justices across ideological boundaries were basically, their main lesson was, how the hell am I supposed to do this? You know, as Elena Kagan, cracking up the courtroom, put it, we nine are not exactly internet scholars. And Google is saying, look, if you let this happen, you're going to allow so many lawsuits and so many different theories, and it's going to deluge the court and completely constrain us. And that was a fair bit of the conversation. Chief Justice Roberts was saying, I'm not sure I agree with your parade of horribles, but there sure will be a lot of lawsuits. The Solicitor General, that is the lawyer for the government, Malcolm Stewart, basically conceded there are going to be a lot of lawsuits if you do this, and they were urging the court to do it, to give them a sliver of liability for Google, etc. But his answer to the flood of litigation argument is, however, none of them, almost all of them, won't go anywhere. That's not something that gave the justices a lot of solace. You know, they're just really worried about the federal courts being completely overwhelmed with these things, and Google, not the most sympathetic defendant, but still, in maybe unfair ways, having to have, quadruple their legal staff just to handle all the lawsuits that will be coming. And their main message was, this really ought to be for Congress. If Congress, when it wrote 230, left a little bit of room and it's not a good idea, Congress should fix it. Now, of course, the people who want the court to decide were saying, look, the law's in front of you. You decide it first, and then it can go to Congress. That didn't really sit that well with the justices. And I spoke with people who were in the courtroom, and the basic consensus is that the justices are going to look for some way to really do no harm. If they had their druthers, they might just punt it to Congress, but there is a case in front of them. They need some decision. So look for something very narrow, and the overall message being, Congress, please fix this. We can't. Okay, so there you have it. Those two decisions will probably come out at the end of June. They'll be closely watched, along with a handful of other cases in the Supreme Court, like the affirmative action case. As they start to issue, that'll be among the more interesting parts of the whole year for me, that June cycle where the big Supreme Court cases come out. I'll be sure to be here to tell you about them. Until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.